Dear students, and today and the coming classes, we are going to discuss about the last module of this particular course, that is the dispute settlement system. So, the GATT dispute settlement system and the WTO dispute settlement system we are going to discuss in the coming classes. And today, we are going to see the GATT dispute settlement system. As we know that the dispute settlement system is the cornerstone of every international agreement or arrangement, without which, and there is, if there is no dispute settlement and the parties are going to be not satisfied by this complete system, and if the disputes are not resolved, then there will be tensions, problems among the members of an international agreement. So, dispute settlement is a necessary mechanism for the amicable resolvement of disputes between parties of any agreement. So, today we are going to look into the GATT dispute settlement system and how it is developed from 1947 to Uruguay round of negotiations through the different rounds, especially the Kennedy round and Tokyo round, and then to the Uruguay round of negotiations. So, the dispute settlement system and which is propounded in GATT was to amicably resolve the disputes between the member countries. The objective of GATT, the single objective was to promote international trade by reducing tariffs and removing impediments to international trade. So, all the tariff and non-tariff measures removal that is happened between the GATT 1947 and the WTO agreement in 1995. So, initially the GATT was set up as a bundle of agreements to reduce tariffs, and you can see a very rudimentary stage of dispute settlement was provided in the GATT agreement, article 13. So, that was the only provision which talks about dispute settlement, and there was no definite mechanism was provided in the GATT dispute settlement system. And this basically this particular provision 13, we will see elaborately on article 13, and the basic system was provided to deal with two kind of disputes among the members. And the first was, if one party alleges that the other party violated any one of the provisions of the GATT, then such parties can complain to the GATT Council for dispute settlement. And second, if any party, any GATT party made an objection to the practices of another member which was against the GATT agreement, or an adverse effect on the objecting party or the other member, then also they can approach the GATT Council for with this particular dispute, and the GATT Council will look into it and will be coming out. We will see that what are the procedures and mechanisms adopted by the GATT Council at that point of time for the dispute resolution mechanism. And we can see that dispute settlement, we talked about GATT and WTO, there is a lot of differences between these two. And the WTO dispute settlement is considered to be very advanced, which was developed in the Uruguay round of negotiations. The agreement on understanding of the dispute settlement understanding, which was concluded in the Uruguay round of negotiations. So, the GATT system, so in the coming classes we will see that how the DSU also works, but the GATT system worked for 50 years from the very rudimentary provisions of and 23. So, one provision which you can find it, and it is worked for, so you can see that article 12 and 13. I think in the previous slide there is a, it is 12 and 13. So, these provisions which provides clearly the entire management of the dispute settlement under the GATT system. And this GATT system was a very simple system of dispute resolution. So, article 13(2), which provides that contracting parties themselves and acting jointly had to deal with any dispute between individual contracting parties. It means that you comply to the GATT council, the members themselves constitute a committee and they will look into the dispute and they decide the case. So, that was the preliminary form of dispute settlement, and finally, it will become a ruling by the consent of the chairman of the GATT council. So, this was from 1940 to 1950 and very rudimentary stage. You sit together and resolve your disputes. That was the method which is adopted up to 1950s. Then again you can see that. So, it means they are acting jointly. I said that the article 23, article 23(2) clearly says about the members should jointly resolve the disputes themselves. So, the GATT council, the chairman at GATT council played a crucial role in resolving the disputes in the early times, the early days of GATT. Then later on the number goes up. These disputes were referred to working parties, and these working parties consist of representatives of all interested parties. So, parties to the dispute and other members also were included in these working parties. So, these working parties adopted the reports by consensus. What consensus? It's a meaning, consensus have a wide meaning under the GATT. So, under the GATT it was positive consensus, and we will see elaborately that what you mean by positive consensus, and then finally the decisions were taken. And later on these working parties converted into panels. So, they were replaced, these working parties were replaced with panels. So, these panels consist of 3 to 5 independent experts, and who were unrelated to the dispute. So, they were starting writing independent reports, and finally these reports were given to the GATT council, and once the GATT council approves the report, and it will become legally binding on the parties. So, from the rudimentary stage to the independent members, the panelist, the appointment of independent panelist was happened in a very short period of time. So, you can see that before the Kennedy round of negotiations, the panels were started forming. So, under article 22 and 23, so certain requirements are made, even though there was no elaborate procedural requirements. And what are the requirements? The requirements are that every member has to prove that there is a violation of GATT provisions. And also the second criteria to be proved by the complaining party was that any benefits have been nullified or impaired accruing to them through the GATT, the GATT provisions, GATT agreements. And if any benefits nullified or impaired or impeded, then the GATT member can complain. And the main criticism, we will come to the main criticism, the main criticism was with regard to adoption of the reports. The adoption of the reports by consensus, and also this consensus is a positive consensus of all members. It means that every member has to consent to these reports prepared by the panels. So, we said that the working parties were replaced with panels, and then the panels were wrote the reports, then submitted to the GATT council, and finally, the council approves or the chairman approves, and then it will be circulated to the members, and it become the legally binding report. And then again you can see that in 1952, when we can see that the developments using these panels using is started in the 1950s itself. And panels, most importantly, they are independent persons or government delegates, independent, nothing to do with the parties. So, the evolvement is started, independent persons become the panel members, and they started independent reports. So, this is actually started the third party adjudication. The earlier system was the parties are also part of adjudication. So, third party adjudication was started from 1952 by the constitution of panels. And most importantly, the 1970. So, we can see that this positive consensus became a big problem when the US started, EZ and the European Union and EZ started blocking reports. So, the one of the starting point was the disk case brought by the European Economic Community against the US, and you can see that the counterclaims and claims and blocking of reports made lot of problems to the GATT dispute settlement system. And also you can we can see that this positive consensus become an impediment to the dispute settlement. So, if you look into the the dispute settlement, we said that decision making process become very difficult due to this positive consensus. So, what is this positive consensus? Positive consensus is nothing but every member of the GATT should agree to such reports. So, that means the panel will come out with the report, it will be submitted to the GATT council, and every member has to agree to this particular report. So, this is the positive consensus. It means there should not be any objection from any member, including the parties. So, and also you can see that the parties, as I said, that the parties to the disputes also were included in this last decision making process. So, it means the third party adjudication will be done by the panel, and the reports will come to the council, and the council includes the parties to the dispute as well. So, any point of time, the last moment when adoption of this particular report, the opposite party can object or veto this particular reports. And this positive, in many times it is started the blocking the reports. So, this procedural lapse, so you can say that a procedural negative which made it very difficult for a report to adopt. This is our perception, but the case was not like that. In the initial times, the system worked very well. So, the GATT membership was very less, and the number of disputes also was less, and the common decision making was smooth, and many reports were adopted. But when you see that from the disputes, so some of the nations felt that this particular system is not good, and because it is unsatisfactory, because after the all effort the members to the dispute can block this particular the reports. And you can see that even though you say that this positive consensus has made a stumbling block, and lot of reports were blocked. So, within the GATT there is sizable number of reports were issued. There are 132 reports were adopted between 1947 to 1995, and also 8 out of 10 disputes, the so called measure which was alleged in the disputes was withdrawn after the dispute. So, it means that the dispute settlement system was very successful. Even though there is only 2 articles, that is 22 and 23, no procedural aspect was prescribed under these 2 provisions. So, some of the scholars argue that this was a power based system, and some of the scholars argue that this was a rule based system, and I would say that the power based system became a rule based system. And adoption by positive consensus, everybody was pointing out only one point, that is as a drawback, adoption by positive consensus, and this positive consensus made a lot of hurdles. This is the argument. And also you can see that the major you can say that allegations or challenges faced by. So, instead of judicial solutions, it was really the panel solutions, or it is more of a diplomatic solution, and negotiated decisions. So, that means even though it was panels, mostly it is of negotiated decisions. And so and also the people say that it was not used very strongly like the present WTO system, and some of the main users were United States and other countries, but still you can see that there are 132 disputes came before the GATT and 132 reports issued. And another drawback which was pointed out was long delays, and implementation was always a problem. There is no procedure for implementation of the reports, even though most of the members 8 out of 10 members were changed their measures. And then this positive consensus which leads to one party blocking adoption of all the reports, even though 3 panelists or 5 panelists. So, even the losing party can block, which we talked about. So, mostly, so you say that even though it was not truly a rule based system, and even though the panels are decided the cases on merit, and it is more of a diplomatic solution, which has happened in the GATT dispute settlement system. So, one such drawback, the main drawback pointed out the GATT dispute settlement system was veto power, blocking of reports, and the agreement dispute settlement system applicable only to the signatories and non-members, it is not applicable. But you can see that the numbers, the statistics says that, and the only 21% of the disputes were under the GATT system, and 58% of the disputes were after the Tokyo round of negotiations under different codes like Customs Valuation Code, Anti-Dumping Code, and other codes. So, it simply says that only 21% under the GATT, 58% of the disputes were under the post Tokyo round of negotiations. It means in the GATT system there is very less number of disputes, and after the Tokyo round of negotiations the dispute has many times, it is doubled or triple times. There is a lot of disputes after the Tokyo round of negotiations. So, the 58% was the blocking of reports were found after the Tokyo round of negotiations. So, it means that before Tokyo round of negotiations, the blocking of reports were not very common, and this blocking of reports started with Tokyo round of negotiations. So, this particular the data, the authors, the different authors, they shows that the how many reports were blocked in the pre-Tokyo round, post-Tokyo round, and in the WTO system. WTO system is a first quarter data. So, here you can see that 1950s. So, that means the 50s it is only 21 cases, 60s only 5 disputes, 70s it is 15 disputes, and post Tokyo round there are 47 cases. So, hardly there is 41 cases before the entire Tokyo round of negotiations, and after the 1980s. So, 80 to 95 there are 47 disputes total, rulings, not dispute, rulings. Then now you see that blocking 1950s 0 blocking, and 60s 0 blocking, 70s 0 blocking, and post Tokyo round there are 2 blockings, and 2 plus 8 total 10 blocking. So, it means before 1950s there are only 1 blocking of reports, 60s 0, 70s 0, and then 1980s the number has rose to 10 disputes, the reports were blocked, and 21% of the rulings. So, you can see that it is blocked by members, 21% of the reports were blocked. When compared to the WTO, the blocking provision was disappeared and all reports were adopted. So, the adoption of the reports was complete. So, you can see that there is 70% more number of disputes were arose between the first decade of WTO. There are total 74 disputes during the first 10 years, and which shows that the number has gone up like 70% more disputes in the WTO dispute settlement system when compared to the GATT dispute settlement system. So, that is why I said every scholars argued that this positive consensus system made a stumbling block, but actually the data says that it was not, because it is clearly the percentage of total rulings and appeal blocked, only 1 report blocked in the 50s, 0 in 60s and 70s, and 21% only blocked in the post Tokyo round. There is the reasons, because there are individual agreements which provides for dispute settlement, anti-dumping agreement, anti-dumping code which provides for dispute settlement in the agreement itself, and customs valuation code, there is a dispute settlement provision within the customs valuation code. So, the disputes increased. So, I want to say that, so our perception is that all literature which says that this positive consensus made a stumbling block to the GATT dispute settlement system, it is not true. That is my argument based on this particular data. Then the GATT experience, which clearly says that there was no much the disputes between the parties, and the interest of the parties were protected. The veto right was rarely used before the 80s, and after the 80s, yes, there are there is more number of blockade of the reports, and the reports are adopted by the members before the 1980s. And also you can see that the solutions, I said it was not completely the judicial decisions, it is negotiated decisions and diplomatic decisions and negotiated decisions. So, there was more acceptability to the parties. So, the implementation was more easy, even though there is no implementation provision in the GATT dispute settlement system, and 8 out of 10 disputes were the measures were withdrawn by the members. So, the veto, so I said that the veto power was very sparingly used by the members before 1980s. So, we were talking about the the scenario has changed with the Tokyo round of codes. The Tokyo round negotiations happened from 1973 to 1979, and the Tokyo round negotiations come out with individual codes like anti-dumping code, customs valuation code, and SPS measures, TBT measures, and all these individual codes have dispute settlement mechanism provided. So, every member has used this particular provision for and raised the disputes before the GATT council. So, the number has gone up. And also in the Tokyo round of negotiations, actually the members were highly dissatisfied with the GATT system of dispute settlement, and they want to come out with an agreement or code or understanding, but it was not happened. But the result, they come out with a document which is known as understanding code. It is a codified practice of from since 1947. The codified practice of the dispute settlement was they come out with the document, that is understanding. But some of the provisions were ambiguous, and whether a complainant have an absolute right of asking for constitution of a panel or not, that was not clear. And what will happen to the veto power of members, how the panel reports are adopted, it was not clear. So, that particular understanding agreement, understanding code was not adopted in the Tokyo round of negotiations. But the Tokyo round of negotiations open up the dispute settlement in each and every agreement. So, during the 80s, what we said, the number of disputes has gone up, and in most of the areas, because each and every area is some of the areas were very politically sensitive, and these areas of contracting parties. So, trade off, the parties has gone on with trade off between members and being negotiated. This dispute settlement system was used as a negotiating tool. So, you file a case against the other, so he will come to your negotiating table. So, this was case 1980s, and so the number of cases gone up like anything. In the Uruguay round of negotiations, and this was one of the most important discussion point. So, the earlier understanding document was again discussed and included the practice or the jurisprudence of the GATT practices, and then come out with the new agreement on dispute settlement understanding or the DSU. And there is no separate procedure for each code, only a single procedures and single dispute settlement mechanism was provided under the WTO, unlike the Tokyo round of codes. And also the positive consensus mechanism has been abandoned, and a negative consensus mechanism was introduced. So, negative consensus means that if majority of the members oppose to a particular report, then it is not going to be adopted. It means that whether it is a party or one member or two member, and out of 164 member countries, even 10 members oppose, nothing is going to happen, and we do not have the experience of non-adoption or rejection of any report in the WTO system. So, the blocking stage was eliminated, and most importantly, all the reports were automatically adopted by the dispute settlement body, and there was no appeal provision under the GATT, and appellate provision also was made. Appellate provision also was made under the dispute settlement understanding agreement. So, under the dispute settlement body, it works in two stages, that is at the panel stage and the appellate body stage, and these reports are automatically adopted, even though it was with the consensus, and that is with the negative consensus. And you can find number of changes in the Uruguay round of negotiations to the agreement. So, DSU have specific deadlines. So, one of the most important allegation against the GATT dispute settlement system was its prolongation of procedures. There is no deadlines, and this was removed, and specific deadlines were given in the dispute settlement understanding of WTO. And you can see that with dispute settlement, and it is applicable to all agreements. That is another development, innovation which is made in the WTO dispute settlement system is this dispute settlement system is applicable to all covered WTO agreements, not individual agreements, all agreements. And the blocking of reports were become impossible under the WTO system, and the dispute settlement body adopts all panel and appellate body reports, and unanimously, even though there is an opposition, it is nothing will going to happen. So, negative consensus system which was introduced in the WTO dispute settlement system. Appellate review, I said that the appellate body was constituted. So, all appeals from panel will go to the appellate body on question of law. And also the system worked, the GATT dispute settlement system worked very well from 1947 to 1995. And also the dispute settlement, even though very rudimentary stage, no special provisions for procedure, but the system almost handled 130 disputes and come out with the rulings in 130 disputes, even though there is more number of cases came to the GATT dispute settlement system. And it was successfully done mainly because of the GATT used alternate dispute settlement mechanisms, negotiations, mediations, and finally the panel reports. You can say that it is something like that of arbitrations, and finally adopted by the GATT Council. So, and mostly the systems was used by the United States, European Economic Community, and Japan also is included. And from the 80s, the US and other parties were started blocking the reports, and which was made a problem to the entire working of the system. And the GATT was not collapsed, and I would say that it worked very well from 1947 to 1980. It worked very well from 1980 onwards as well, but the number has gone up, and the blocking of reports was also increased mainly due to the number of reports against the trading countries. So, in the nutshell, in conclusion, I would say that the GATT dispute settlement system from 1947 to 1995 worked very well, even without the procedural formalities. It worked based on consensus, it worked very well based on negotiations, it worked very well on consultations. So, the GATT, even though most of the scholars say that it was not a success, but I would say that it was a highly successful system under the GATT negotiating systems. And in the next classes, we will see that what is the WTO dispute settlement system and what are the improvements made onto the GATT system, and the jurisprudence, what is the effect of jurisprudence on the GATT, the WTO system. Thank you.